proposals, but when I say they're concrete, they're already applying for certain permits in the state. There's at least 30 projects. They're all tied to new oil and gas infrastructure. So the primary reason that we're seeing this hydrogen hub build out is really to use the natural gas that's in the ground, and that's why it's in these states where there's still a lot of natural gas in the ground, like Ohio, West Virginia. That is not coming through. I don't know that we need this slide. You probably already talked about what carbon capture is between direct air capture, capturing carbon at an there we go. Capturing carbon at an emission source, so fuel exhaust, and then carbon capture from just trees. They're probably our best form of carbon capture. And I teach a class at the University of Akron, and the last couple of years, as this stuff is being proposed and carbon capture is being supported by a lot of politicians in all these states, Democrat and Republican, I asked what they think carbon capture is, and almost everyone has said they think it's taking the carbon out of the air. And then I asked, well, what do you do with it when you take it out of the air? And nobody ever has an answer. But the answer is inject it into the ground. And so just start the presentation again.
Yeah, sure.
I think it was just a slide.
Is that working now?
Yeah, missing a slide. Up there we go. And so I'll talk a lot more about the Safe Drinking Water Act underground injection control program. But basically, most of our injection well programs are designed to get rid of waste. So the Class 2 program is probably the most well-known, especially in these states like Pennsylvania and Ohio. And that's how you get rid of your liquid oil and gas waste. You inject it deep into the ground. Other ways to get rid of waste, of course, is landfills, burn it. But for carbon, really the only way that we know to get rid of this waste is to inject it into the ground. So long-term or permanent storage is one way that's theorized to get rid of it. We don't really have a lot of that in this country. There are 2 wells that exist in Illinois. It's relatively low storage compared to the extremely high volume of storage that's being proposed for these projects and these hubs. Then the way that has been done on a relatively large scale, really only in a few, like Texas and California have the vast majority of EOR wells. But that is utilization, so you inject the carbon into the ground to pull out the remaining oil that's kind of hard to get to. And the reason that works, by the way, is carbon, well, for one, it was, once you have it, it's a cheap way to get this enhanced oil recovery. And 2, it works. It wants to come back to the surface, or it migrates upward once it's injected. It wants to come back to the surface. So it's very tricky to store permanently. So I'm going to skip over a lot of this for interest of time, and a lot of it's been covered. I do want to talk about community impacts, because a lot of I represent clients. A lot of the clients that I represent, a lot of the groups that I just work with in coalitions are just as concerned about community impacts as anything else. So Pennsylvania, we only have I think 10 to 15 Class 2 injection wells. I say only because I'm comparing it to Ohio, where we have hundreds of them. So I don't know if folks here have experience with talking with communities that are around injection wells, but they are deeply unpopular. They're essentially a nuisance. There's noise, they're loud, the waste spills, it causes earthquakes. There's an injection well in Youngstown, Ohio that was found to have caused a 4.0 magnitude earthquake. There's a lot of seismic activity that's correlated with injection wells. It just hasn't been studied well enough probably to connect them to injection wells. But just the injection well itself is a burden on communities. And again, this is waste we're talking about. So when the DOE initially came out and said, oh, getting these projects is actually a benefit to environmental justice communities, so working in Louisiana, where some of the first meetings were held after DOE came out with all this, they got loud and immediate pushback, and I saw a meeting where Secretary Benholm completely walked that statement back. I don't know if they've ever done it in writing, but we have seen at least EPA come out and acknowledge that these are environmental justice burdens, and at least in the primacy applications, which I'll get to, environmental justice analysis has to be done to attain primacy and for any agency that permits plastics injection. But there are other impacts. Carbon pipelines are going to have to be used to get the carbon to the injection well. Now for other injection wells, you can truck stuff in. This happens a lot with oil and gas waste. But right now for carbon, the way that we transport it is through a pipeline. And even a lot of that is still pretty theoretical. There are some carbon pipelines in the country. There aren't many. I was in a presentation with an expert who designed pipelines for a long time. Because of the nature of the carbon pipeline, you can't just use existing natural gas pipelines, for example. Carbon is too corrosive. It has to be kept at a certain pressure in order to keep it in what's called a supercritical state. And I kind of roll my eyes because like when I was first learning about this, it sounded ridiculous, but the supercritical state that carbon has to be kept in through transport and injection and theoretically the storage. Because again, if it's not in this state, even when it's in the state, it's trying to migrate upward. But when it's not, it's really hard to contain. Just having the worst luck with this. But the supercritical state is not, it's been described to me as not quite a gas, not quite a liquid, which sounds to me like quantum physics, and it's like, what are we doing? Like, can you give me a better explanation than that? What is it? I guess it's more of a liquid than a gas, but that's the best explanation that I've heard. We've already talked about the funding for this. The only thing I'll say about the hydrogen that it's kind of been covered, but I just want to highlight, for primacy, it's true that the DOE and even the Biden administration has said that they want to encourage states to apply for primacy and even speed up that process. It should be noted that EPA has never said they want to speed up the process. They just said they're interested in helping states obtain primacy. But the reason for that speed up has always been to meet greenhouse gas emissions goals. So, and I've said this, since I've been started working on certainly Louisiana primacy, but even West Virginia is in the process of applying primacy. I've had conversations with EPA staff, and it's in our comments in the Louisiana application, that goal is not met by these states that want to build out the oil and gas infrastructure, so the blue hydrogen, because of the upstream greenhouse gas emissions, because of the upstream methane emissions along the way. And there's no like great way to calculate that compared to what theoretically we captured, but it's at least not we know that it's at least not a great benefit. So we certainly can't know that you're going to capture more than you're ultimately going to get upstream, partially because oil and gas activity has been so under-regulated that like upstream emissions, we mostly have to go back and figure out like, oh, where did all this methane come from? Because there's not a lot of monitoring at a gas well, for example, for methane emissions. So I just wanted to make that point that for these primacy applications in the states that I'm going to talk about, and the states that are really pushing to get it, Louisiana, Texas, West Virginia, Ohio. I'll talk a little bit about Pennsylvania. I know they've said they are interested in getting primacy. The projects and the build-out that are going to be proposed, I think EPA should not do this thing where they're kind of speeding up the primacy process, because these states getting primacy does not actually helping our greenhouse gas emissions target. So there are a lot of legal issues involved with disposal, some of which haven't really played out yet to the point where I can give you like what the law is on this, and many of which we just don't know what are going to pop up because this honestly just hasn't been done yet, certainly not in this country. Really worldwide, there isn't a lot of large volume storage of CO2 underground. But pore space ownership is a big legal issue because this is how you decide, who owns the space where we're going to inject the carbon. So who do we lease with? Who do we buy that ownership from? The disposal authorization right now, this is the Class 6 injection well program, like I call it. That's how you get your authorization to dispose of the carbon. Potential liability, long-term for stored CO2. The questions arise like, how long is the operator responsible? Once they're no longer responsible, if they are no longer responsible, does it go back to the landowner? Does the state take responsibility? Things like that. And then, how are CO2 pipelines regulated? I'll talk a little bit about most of these things, but honestly, most of them just haven't been worked out. So, pore space, this is just voids in the subsurface that can be used for sequestration of carbon. Most court decisions, and there haven't been a lot, hold that the owner of the surface estate, owns the pore space. The exception is, right, if you're, let's say you have an oil and gas lease, if that lease says that you also lease your pore space, then yeah, that contract is going to hold up. Most oil and gas leases don't say that because this kind of thing wasn't complicated. I'm sure they would have if they knew this was coming, but most of them don't say that. So best guess is in states where there isn't legislation that the owner of the surface estate, the court will find that they own the pore space. West Virginia does have such legislation. I think Pennsylvania, it's proposed. I don't think that it's final yet. That owners of the surface estate own the pore space. But again, it could be modified by these. This was already talked about a little bit. I just want to make the point that, I think my point here is that states that want to do this, we're going to start seeing legislative proposals on all kinds of issues related to pore space. One of them is under state lands. So West Virginia did pass laws that allow the state to lease pore space under state lands. This is also significant for private landowners because we're also seeing laws passed that could force people who own pore space into units, like bigger units. We call this forced unitization. And these laws, so just a little bit about that. In Pennsylvania, you have what's called forced pooling. And I think the best way I can describe the difference between the way those two things are used. Forced pooling, you only get to take the amount of land necessary to meet well spacing requirements. So this was, the well spacing requirements was just so that your neighbor couldn't stop you from developing your oil and gas, whatever your minerals are, because you were too close to their land or a home or something like that. But unitization is different. All that is, it'll say something like, you propose a unit as long as you have leased something like 65–70% of the unit. As long as you have that leased, you can take the rest. You can force the rest of the land. And I think the reason that state lands being up for pore space leasing is significant. You see state lands get leased at the rate like 300 acres at a time. So if you have that in some private land, you can end up leasing somebody's land. They might have 100 acres that you could just force them into a lease. So it's also like a private land, private ownership issue, pore space issue. All right, so the meat of the law. So the Safe Drinking Water Act Injection Well Program. It's housed in the Safe Drinking Water Act. The Safe Drinking Water Act was passed in 1974. A big part of the Safe Drinking Water Act is your water standards. This is how drinking water standards get set. Another part of the Safe Drinking Water Act is this underground injection control program. This controls the injection of waste or other chemicals or fluids under the ground. One thing to note, this was always designed to protect underground sources of drinking water, which is defined to an underground water source that can support like so many community members. I forget exactly how many, but it's not big enough. And then less than 10,000 milligrams per liter of TDS, which that's salt water. So it's most of your underground water until you get very deep is protected by the Safe Drinking Water Act. But it was never designed to do things like prevent earthquakes. So the more issues that we're seeing with like high volume injection, we're seeing that even EPA has a hard time figuring out how to regulate it under the Safe Drinking Water Act program. There are 6 classes of injection wells. Not all of these, so class 4 wells I think are now banned. So there aren't a lot of wells in all of these areas. There's very few class 1 wells. We actually saw this play out with the East Palestine disaster. They couldn't figure out like where to dispose of the waste. They wanted to take it, there's a class 1 well in I think Vienna, Ohio, somewhere around there. And they wanted to take it all the way down to like Louisiana or Texas, where they have actually the most class 1. There's not a lot of those. There's a lot of class 2 wells relative to the other programs. The most is class 5, and that's because these are mostly like non-controversial injection of stormwater, things that would already end up in the environment. You're just somehow like injecting it to a different place. I will say class 5 you're going to see as these class 6 wells start to be proposed in this area. And I say that because Louisiana they're like really the test case right now because they're so much further along than our region. But we're seeing class 5 wells first be drilled as these stratigraphic wells. So to get the geologic information to put in your class 6 well application, we're seeing class 5 wells being drilled. And the reason it's under the class 5 well program is that is also there's like a little catch-all for experimental kind of injection wells. So that's how these fall into the class 5 well program. And we're also, at least the 2 that I followed related to a facility called Air Products, and Air Products was mentioned earlier because they have a project in Texas, but they're proposing another one in Louisiana. Their class 5 wells are being designed to handle carbon, so the construction design, and they've said, not formally, but they've said that they plan to just convert them to the class 6 well. There's a lot of question about like, is that even legal? Because there's nothing in the class 6 well rules that allow you to convert a class 5 well to a class 6 well, but that's happening. So class 5 you're going to see in relation to class 6, particularly like before the class 6 application is submitted and finalized with EPA. So another note about the class 6 carbon dioxide long-term storage program. It is the newest class of injection well program. It was finalized in 2010. And most of your classes of wells, what you have in your minimum federal regulations, you have like one regulation that covers like 3 or 4 at least of the injection well program. So like class 2 and class 3 are very often grouped together. But class 6 needed its own program, and EPA recognized this in their rulemaking and in their many guidance documents that they created for the class 6 program, that there really isn't anything concrete to point to for these rules as far as like how they work, how the testing will work, or anything like that. So we're probably going to need to go back and revise our rules once class 6 wells actually get going. The idea was always to have like test projects. What we're seeing now is money's being doled out for test projects that are really just like real projects and part of these hubs and stuff. But it's a new program. It was always designed to be updated. It never was. And now EPA is just so overwhelmed with applications, not just for primacy, but for class 6 wells. It's hard to believe they have time right now to go back and update those regulations. Just a note about, so as these applications come in and as you hear like industry talk about carbon disposal, they'll say, we've been doing this for decades. We've been doing this safely for decades. What they mean is they've been doing enhanced soil recovery for decades. They have not at all, ever, in this country, done long-term carbon storage, ever. The 2 wells are related to like an ethanol project in Illinois. It's nowhere near the scale of what is being proposed. But there are major differences between the Class 2 program and what, theoretically, the Class 6 program is supposed to do. So the biggest one, in my opinion, is the carbon is supposed to come back in EOR, right? You inject it so that it brings this stuff back. For Class 6, it is not. It's supposed to be kept in a very supercritical state, and it's supposed to remain stored underground forever. Now, another thing that we've seen is EPA has said that they would allow storage and then use for EOR. And they've said this in their processing of Louisiana's primacy application. And again, I just think if you're really like doing this to not only support oil and gas projects, but also to use the carbon to eventually do EOR, this is not purpose to meet our greenhouse gas emissions goals. This is just purpose to use the gas that's in the ground. It's really just a benefit for oil and gas emissions. For EOR, there are a lot of wells. I don't know how many are active versus idle. They're mostly in 2 states, though. So we have a lot more information about EOR, how it can work. Like I said, there's 2 in Illinois in the United States. There's 1 more permitted in North Dakota, I believe. I don't think that well is operational. So we don't really know yet how they're going to work. We certainly don't know how they're going to work from injection to site closure, which has never been done. And then the purpose of the Class 6 program is to keep the carbon stored permanently to support reducing CO2 emissions. That is not the only purpose of the EOR program is to get more oil out of the ground. So they're completely different programs. So I just think it's very misleading for the industry to say we've been doing this in this country for decades. It's not true. And by the way, go look at what's happening in Texas with Class 2 wells and EOR wells. It's a nightmare. They're having to completely reduce the scale because there's oil and gas waste popping up like all over in Texas. So they haven't successfully done it either. I'm just use this graphic to show all the different ways CO2 can escape from the formations. Again, it's going to, even in the supercritical state, it's going to try to migrate up it. So they can escape in gaps in rocks. The injection itself creates new fractures and fissures that it can escape to. The pressure from the injection creates new fractures and fissures as well. And you just know, like, we don't have a perfect picture of the geology this deep under the ground. So you can never just be 100% certain that it's going to stay where it is. Certainly not like forever. And I just think it's funny, some of the remedial measures like intercept and re-inject CO2. First of all, good luck intercepting the CO2. What are you talking? But also re-inject it right after it just got away. But I do want to talk about abandoned wells, because in Pennsylvania, this is a very serious concern if we're talking about Class 6 injection in Pennsylvania. This is the primary leakage pathway for CO2. And I can tell you that both active wells and orphan wells in Ohio, where there are hundreds of Class 2 injection wells, have seen Class 2 injection well waste migrate into the well, make its way to the surface. You've had big fish kills and things like that. So in Pennsylvania, like Ohio, I think even more so in Pennsylvania, there are hundreds of thousands of historical oil and gas wells, called orphan wells, that have not been plugged, or if they had been plugged, the plugging procedures used back in the 20s, 30s were not sufficient to completely plug a well in a way that would stop CO2 from escaping to the surface. And so in a state like Pennsylvania, class 6 injection is especially risky because we haven't located all the organelles. We certainly haven't properly plugged them. But the same is true for West Virginia, same is true for Ohio, same is true for Louisiana. All right, so the current landscape of primacy, there are 2 states with primacy, North Dakota and Wyoming. North Dakota has issued 1 permit so far for class 6 well. Should be noted, both of these states were approved during the Trump administration. For both states, EPA has said that it took 6 to 7 years from the time that they started their application to the time of approval. And at the time that these were approved, not only was it a different administration, there wasn't this like concrete money for these hydrogen hubs. There wasn't these proposed carbon capture hubs. So there wasn't the same kind of discussion and public interest around primacy at the time like there is now. But now there are a number of states in the application phase. A couple I'll highlight. West Virginia is in this region certainly the furthest along. They're in talks with EPA. They've passed their rules for the Class 6 program. When I talked to EPA staff, they've said West Virginia isn't particularly close at having their application deemed complete, that they would have to update their rules. They didn't give you many details on that. But they seem like they're still a little ways off, but certainly further along than Ohio, there is legislation passed in Ohio that says that directs ODNR, the Ohio Department of Natural Resources, to create rules. They haven't done that yet. Certainly more in Pennsylvania. Now I know in Pennsylvania, I think the DP or somebody sent a letter saying that they intend to apply for primacy. In my opinion, they're a long way off. They have to create their rules. Pennsylvania doesn't have primacy over the Class 2 well program, so it's hard to believe they would have. I'll get into this. I don't think if you have expertise in the Class 2 program, you have expertise in the Class 6. But certainly, if you're not even running the Class 2 program, you're going to have a hard time making a quick showing that you have expertise necessary to run a Class 6 program. So I think Pennsylvania, the 3 states, is the longest way off. When we talk about like where the proposals are going to end up, I certainly think the ones with the most ties to West Virginia are probably going to move the quickest because for reasons I'll talk about in a minute, if these hubs are proposed in states that don't have primacy, it's hard to believe they'll be built out in a quick period of time, and of course that's going to affect how much private funding they're going to get, which they're offering. So the Louisiana application. So this has moved to proposed approval. There was an initial comment period. I represent clients participating in that comment period. I say initial because while the comment period was going on, the Louisiana legislature updated a number of provisions in the Class 6 program. And EPA opened up a limited comment period just for that legislation. So the comment period is technically still open, but only for a couple of issues. This is certainly the furthest along. Louisiana has what I believe are a lot of major issues with their primacy application. The 2 which I want to highlight for today's discussion are they have a complete liability waiver after site closure. So the way that the regulations work after you are done injecting, and this is only true for the Class 6 program, by the way. So again, EPA recognizes that this program is much different, much more risky. So after you're done injecting, for a period of time, you have to have a plan to monitor the site. Monitor your CO2 plume under the ground and monitor the site itself. That general time frame in EPA's regulations is 50 years. In Louisiana's regulations, it was 10 years. In West Virginia's statute, it is 10 years. Now, in order to get primacy, your regulations have to essentially mirror EPA's or be more stringent. So right there, Louisiana, when they submitted their application, was clearly in violation of EPA's regulations. And the reason I think it's noteworthy is EPA proposed to approve it anyway, and they bent over backwards to try to fix that by putting in their memorandum of agreement between the state and EPA. So that part of their application, they amended it to say, Louisiana just promises to implement the program consistent with EPA's regulations, including the site closure requirements. And I don't know if they've seen how much like oil and gas industry is prone to litigate, but if they have a statute in place that says they only have to monitor for 10 years, I think they're gonna feel pretty comfortable about that lawsuit compared to some contract between the state and EPA. So that was one major issue, and that legislation did, during the comment period, did fix that part. They changed it from 10 years to 50 years. But even more concerning, what they left in place is, in Louisiana's laws, they have a complete waiver of liability after you get that site closure. So after you're done monitoring, you're no longer liable at all for what happens at the site, and it all shifts to the state. So that's what Louisiana statute says. In EPA's regulations, that does not happen. They don't have a liability waiver. It was pushed for when they created their regulations. They specifically said, no, that we expect you to be liable under all environmental laws and state tort laws, even after site closure. So that's a huge point of contention. EPA has so far just kind of danced around it. And it'll be interesting to see what they do for their final approval. And then the other big pushback is, for Louisiana in particular, they probably don't follow the news much in Louisiana, but they have, especially recently, have been very combative about any kind of environmental justice requirements and permitting. So the Attorney General of Louisiana actually sued EPA because EPA found under Title VI of the Civil Rights Act that Louisiana's permitting practices were disproportionately harming low-income Black communities. So EPA made this finding. They were in talks with Louisiana to come to some agreement implementing more concrete environmental justice procedures in their permitting. And State AG sued EPA. They said things, it was like, it's a ridiculous complaint if you read it. They called environmental justice requirements reverse discrimination against white people. They said disparate impacts analysis is actually racist against white people. So it is, and they called it woke ideology, like environmental justice requirements, which have been, you know, it's been a requirement since the 90s in an executive order. So this isn't like a new thing. So anyway, this state, Louisiana, which has no environmental justice requirements in its permitting program itself, is now being proposed to be handed over primacy from EPA. Once that happens, EPA then can't come in and say, hey, for this permit, we need you to do an environmental justice analysis and consider the impacts in the permitting program. Once you hand over primacy, that's it. The state just takes it over. So it would be pretty appalling if they handed this over to Louisiana right now after that lawsuit. And EPA's reaction to that lawsuit was to close their discrimination case. So they completely backed down. So, you know, we fully expect them to put some teeth somewhere. And so we're hoping to do it in the primacy application process. So the application itself, I'll only focus on a couple of these things because this part of the application is mostly like a checkbox kind of thing. But it contains the regulations, the program description. Those things have a lot of meat in them. But the governor's letter and AG statement that's just kind of formed. MOA is really just supposed to be like what we're handing over to you and what the oversight responsibilities are going to be. And then the memorandum of understanding, again, is just another kind of form thing. So why do states want this? It's because right now, EPA has been taking 6 to 7 years to permit Class 6 injection now. And that is really just not fast enough for the kinds of build-outs that we're seeing proposed. So the reasons for that are limited staff and funding at EPA. At least this is what EPA has said. There just isn't the expertise out there to safely run these programs. Again, what is required in the regulations for a Class 6 well is much, much more than what is is required for a class 2 well, which is probably like the closest comp they have right now. But it's really not close. So right now, EPA, when I started working on Louisiana's primacy application a year and a half or so ago, there were like 10 to 11 applications for class 6 wells with EPA. There are now, I think there's a 30 just in Louisiana. Then there's maybe a little less than that in Texas. But they're coming in, I mean, every time I check it, there seems to be more. So they're getting an overwhelming, for them, amount of application. All right, so the process itself, let me see what I'm doing. I'll try to move quickly here. So the process itself is done in 4 phases. Phase 1, you're just preparing your application and meeting with EPA. That's where West Virginia is right now. That's where Ohio is going to be soon. So that's phase 1. That can take a long time. For North Dakota and Wyoming, this is the process that really took like 4 or 5 years, just preparing your application for completeness. And then phase 2, you submit your application, and EPA determines whether it's complete, and then creates a docket for the application. And then phase 3 is where EPA notices the application in the Federal Register, reviews the substance and elements of the application, so not just the checkbox anymore. And then they determine really whether to approve it or disapprove. So this is where Louisiana is in phase 3. They've held public hearings. There's so much interest in Louisiana's application. And think about how like wonky this is. This class 6 injection well to inject carbon into the ground. There's so much interest that the docket in that application has over 41,000 written public comments. They had to extend the public hearing date by 3 days and have a virtual public hearing. And the public hearing was only held in one town, Baton Rouge, Louisiana. So it's not like they did a good job of holding it all over the state. So a lot of people could attend. And most of those comments are in opposition of the state obtaining privacy. And that is because in Louisiana, like I said, there are so many concrete projects moving forward that the communities have really shown that, oh, this is just another burden issue on us. Here, it's harder to do that because there's so few concrete projects that we can point to. I know there's a couple in the works, but in Louisiana, these projects are already getting like their coastal use permits and things like that in Louisiana. Like I said, there's 30 Class 6 applications. A lot of the projects that we know about, because they're moving forward with their coastal use permits and their Class 5 permits, which the state of Louisiana does have primacy over Class 5 wells. So you also have this weird thing where right now you get a Class 6 well from EPA, but the well that you drill and you want to use for your Class 6 was done through the state. It's kind of messy. But anyway, a lot of these projects haven't even applied for their Class 6 permits with EPA. So we think there's a lot more projects than just 30 that are in the works in Louisiana. And a lot of them are right there along the Mississippi River, and what's termed Cancer Alley, like this 70-mile stretch of river where there's an overwhelming number of petrochemical plants. Like the cracker plant in Beaver County, I don't know if you've ever seen, they do toxic, like a lot of the advocacy groups do toxic tours around there. It is a nightmare, that stretch of it. But you know, a lot of these communities are already well organized, and they were able to really push back on this application. In phase 4 is they just publish the final rule for approval in the Federal Register. And at that point, it is a final appealable thing. So the Safe Drinking Water Act allows you to petition for review to the circuit court at that point. At that point, you can then challenge the approval or disapproval. All right, so just a little bit about the completeness determination. So this will be, with West Virginia, for example, we'll move into this phase at some point, probably within the next year. So at that point, EPA just takes a look at their application to determine if they have all the elements in there. A couple places to push back, and the Louisiana folks had success pushing back and extending this process in Louisiana, was has in the description, describing how the state intends to carry out the program. Louisiana, and they still do, they say they're going to hire staff, they say they're going to contract third-party contractors because they don't have expertise on hand. So that's a real point of pushback all along the process. We can make it early in the completeness determination process. Is we need to make sure that these states can actually safely carry out this program. Because once it's handed over, that's it. It's really hard to get it back. I don't know of a single case where EPA has pulled back primary enforcement authority once they've handed it over. But the rest of this, again, it's mostly just a checkbox thing. There isn't even a public comment period. We have to request meetings with EPA in order to tell them our concerns. The rest of it comes with the substance review in that phase 3. So once EPA moves to that, and all I've really done here is I've highlighted, these are all provisions specific to the Class 6 program. So for example, another thing I want to mention about the minimum regulations, like I said, they were always designed to be updated like once we learn more about carbon injection. So, and it should be noted, so even when they update them, if they've already handed over primacy, the state already has their program. So it's not like the state has to then immediately just update their regulations once they handle primacy. So I have always told EPA it's important to update regulations before you start doling these primacy things out. But in any event, so a lot of the standards are still very general. Like for example, the use of materials and performance standards suitable for CO2 content for the life of the project. General standard, the operator has to show it, the state has to determine it, but it's a kind of thing that is very different than any other injection well, like the way construction standards exist for any other injection well. So you can look to the guidance, which has a little more details, and the only reason I know some of this, because I'm a lawyer, like this stuff gets into expertise that is a little beyond my purview, but I work a lot with a gentleman who helped design the Class 6 regulations in EPA. And he says that one of the reasons EPA moves slow is they just don't have the staff to carefully review this. They have 1 or 2 people right there right now that can do it. He thinks just 1. And it just takes a long time, and there's usually a lot of back and forth for a lot of these things. So the mechanical integrity testing is very different than any other injection well. The monitoring of the pressure is very different. The monitoring, you're supposed to test and monitor the plume. We don't do this with any other injection well program. And right now, it's still being worked out exactly how and what the best way to do that is. Right now, you just have general regulations saying these things must happen. So there's other things, more frequent reporting. The post-injection site care is very different, and I talked a little bit about the liability issues. And then environmental justice review. So certainly for Ohio and West Virginia, for all of their injection wells, there's no EJ analysis, environmental justice analysis. There's no considering the decision based on impacts to environmental justice communities, including denial, a denial standard. So all EPA has done thus far is say, Tom mentioned the governor's letter, they say they want to, in generalities, they want to see environmental justice reviews and mitigation in your permitting program. It's not in Louisiana's, it's in there, and again, after they determined it was complete, they amended the MOA to just say, oh, Louisiana's going to do an EJ screen and consider impacts. And then Louisiana, in a presentation about their program, said they don't have the authority to make decisions based on an environmental justice analysis. So, well, it remains to be seen exactly what kind of environmental justice review EPA is going to require, but I will say I've never seen it required in Ohio and West Virginia for a Class 2 well at all, not even a screen of EJ.
Yeah, I have 2 questions. One is, they only have to take care of the site for 50 years?
At most.
At most. Can they do, I mean, so 51 years down the road, they could literally authorize a zoning change to do construction on the site?
Yeah, I suppose. Could happen. I mean, I would hope that there's something, I mean, I don't know why, so, but I will say that, so, but the operator is still liable for their injected carbon waste in EPA's program even after the 50 years. They just don't have to monitor it anymore. It's still theirs. Like, all that carbon is still theirs. It's theirs.
Well, we hope it's still there.
Well, it's their owner. They still have ownership over it. It's still their responsibility. They just don't have to monitor the site. But if something goes wrong, and assuming those operators still exist, and we've seen countless times with all these fossil fuel industries how they're able to like get around existing while still existing in other forms. You can come back on them to get cleanup costs, order cleanup. For West Virginia and for Louisiana, that would not be the case. The ownership would go to the state.
Is there any authority in the statute that rules for the EPA to turn down a state?
Yes, absolutely. Yep. Yeah. If they don't feel like it meets the minimum regulations, and if they don't feel like the state can implement it safely, essentially is the standard.
So they can turn them down,
For primacy?
but they don't turn them down. In practice, that's.
In practice, I've never seen them turned down. But again, this is a real like testing point for EPA. And I know 2 states have it. It was a different administration. It was a different. The way we were thinking about this was very different. It wasn't so tied to oil and gas and all this spilled out. Like, this is a real test for EPA to see how they're going to scrutinize these applications.
This is more so a question around, so with the responsibility for monitoring the site 50 years maybe, is that also inclusive, is that just the site? Or is there other responsibilities around implications for public health? So just with the spirit of transparency, I know from an EJ perspective, that's also a concern, is cumulative body burden and just them already being vulnerable to public health risk anyway with other exacerbating issues besides this. Is that also inclusive of their, I think I know the answer, but I want to ask
It hasn't been yet, but it remains to be seen what EPA is going to really require for how they're going to implement environmental justice. Like, that would be a mitigation environmental justice procedure, which they say they're going to require. So far for Louisiana, they haven't done it. But so no, all it would be is the site itself and the plume of CO2, monitoring that. So I think for the Illinois facilities, there wasn't like air monitoring, some kind of anything like that.
Thank you.
Yeah.
Yeah, sorry, just a question on the EPA's role and kind of how they're responding to this. Like one of the things I recently learned is that when North Dakota got primacy, like they approved their primacy, their like permit applications in a matter of months, right? Like it's less than 5 months or something like that. Has there been any response from the EPA to that, or like?
Yeah, that's from the time of publication to approval. They had been in talks for like 6 or 7 years. So that application was being worked on for a long time.
Okay.
It's just that by the time it got into publication, they did the completeness determination, they admitted to public. There were like 9 comments. So EPA was just ready to approve it at that time. There was like no pushback. So application. But that's the explanation they gave me. And that one happens.
Can I just confirm? So it was a 6 to 7 year process, and it was only 5 or 6 months that they had the public comment availability. So like for years and years and years, they were investing that time and money into the review and application
Oh
process.
yeah,
Okay.
yeah. Which is the same thing they've done with Louisiana.
James, does the timeframe that you just talked about for full cycle approval, I know in the case of the Fidelis project in West Virginia, at least the developers suggested they're hoping to start up in 2028, which is less than 5 years from now. Is that plausible, do you think?
I do, because I think it's plausible. Well, it's certainly possible, because if EPA approves primacy by 2026, we've seen, not just North Dakota, but we've seen Louisiana say, they plan, back when there were only like 11, 12 applications with EPA, they said they plan to do 6 permits in 2 years. So 3 per year. We think they're gonna move way faster than that. So I think it's possible if these states get primacy, that they're just gonna issue these permits. And they're gonna be, the thing about the expertise is they're gonna be so overmatched by the industry experts who put together the application, they'll just get it and stamp. That's my fear, because they won't know how to push back on these applications.
You had a clarification on my question. I was talking about a well permit, not the primacy permit.
Oh, so you're talking about North Dakota's permit? Yeah, that's exactly the concerns that they issued it.
Within like 5 months after they received the permit
Right,
application
yeah.
was approved.
That's right, yeah. We think that's gonna happen when Louisiana gets it.
So EPA wants to push this responsibility to the states because EPA doesn't have the wherewithal to deal with all these permit applications. But the states probably don't have the wherewithal to deal with all these permit applications either. They're just not the EPA. Is that right?
That's true. And the states that are applying for primacy largely are, their permitting programs are, I'll speak for Ohio and West Virginia, very much captured by industries that want to push this stuff. So the idea is, once the states get it, they'll just streamline it. And EPA is just kind of turning a blind eye to that, honestly, and really addressing it. Their response so far has been that the state will be able to, if we have 16 staff, I think it's 16, and they work on all our injection water programs, the state will be able to hire 3 or 4 people that just work on tests. So they'll be able to do this better. No, Louisiana hasn't hired anyone. They just say they're going to. So like, how do you even know if they're going to, if they're qualified to? They've already said they're going to issue them as soon as they get it. So yeah, I mean, it's a big, to me, it's one of the biggest points of pushback is why, maybe we should be a little careful handling this program. The other point I'll make about primacy programs, Pennsylvania is a good example because EPA has the Class 2 program, they issue a permit. DEP has a Class 2 program, they issue a permit. DEP, for whatever reason, just never moved to get primacy. So they would be more one issuing that permit. What I've told EPA is, if you think Louisiana can do this, let them prove it. Hold the program for a year. Let's see how they deal with their permit applications. Then you issue your permit. You basically have to get 2 permits, just like in EPA for a Class 2 well. And let's make them prove that they can implement this program. Because when you hand it over, you're done. EPA is done implementing the program. And there's a lot of political pressure for EPA to approve these applications. We saw like, who was that senator from Louisiana, basically threatened the EPA, claiming that they're holding over the business. Was it? Was it? Yeah.
Well, they don't need to be threatened because they want to pass the, whatever they call the Clean Power Plan rule now, for carbon capture.
Well,
they got to get that, and they want that moving as fast as possible.
that's a whole other issue is what are going to be the Clean Air Act emission standards when thinking about like if carbon capture does become pushed. And so for example, like there's a facility in Louisiana called Lake Charles Methanol. They are applying, I think they've gotten $1 billion in funding to implement carbon capture on the plant. Their air permit allows them to permit hundreds of thousands of tons per year of carbon. So the air permit says nothing about the best emissions technology being carbon capture. So they're literally getting it both ways. They're getting the money to install the capture, they're getting the air permit as if they didn't have it, just in case it doesn't work. Because they know it doesn't work. They know it. So yeah, they're happy to get money to get it. It greenwashes them. They're getting all this federal money, more subsidies. But they don't want to be held to it. This is frozen.
It's not working.
I just have a few slides left. Okay, we're good. Yep. So other considerations, we've talked about expertise in that. Agency that's getting primacy, their history of compliance and enforcement. I'll tell you that Ohio's is very, very bad at putting it on. And then the big one, it's not in the minimum regulations, but it's allowed to be considered by EPA, is the actual geologic risk and suitability for carbon injection in the region. So, for example, in Louisiana, there's nothing in the regulations to pay any care to like the coastal zones, the levees, anything like that when we're talking about all this infrastructure. And then I think somebody's going to talk about this, but this infrastructure is, when you have an injection well, you're going to have pipelines. So there's currently only 5,000 miles of carbon pipelines in the whole country. And I've seen estimates that would propose to rival our gas pipeline infrastructure. So we're talking about a massive pipeline build-out for a substance that is very dangerous. And we've already seen one incident in Satartia, Mississippi, where the pipeline ruptured, 200 people had to be evacuated, 45 were hospitalized. I've been seeing more and more articles from first-hand testimonies about this story that people are still feeling effects from that incident. And so if it is anything like our failures in our natural gas pipelines, which is easier even to control than the CO2 pipelines, we're talking about a very dangerous proposition building out this kind of infrastructure. And I just want to point out how under-regulated the pipelines are. So right now, FERC has declined jurisdiction over the pipelines. What that means federally is there's no eminent domain authority. It also likely means no, it's called a NEPA analysis, so no big, hard look at all the environmental impacts when these pipelines are sited. Yskamp said they're going to update their regulations, they haven't yet. So citing and regulations is left largely to the states, eminent domain varies by state. Louisiana already has an eminent domain statute. And keep in mind, just because you pass a statute that declares something eligible for eminent domain doesn't mean the Constitution allows it, so those fights will happen when the statute is passed. And then they may need Clean Water Act permits if pipelines impact the wetland. But we've just seen the Supreme Court really narrow the scope of coverage under wetlands. I'm not going to get into that today, that's a whole MCLE. So if they do impact the wetland that's covered by the Clean Water Act, there will be additional review, public comment. But I guess my takeaway here is there just isn't a lot of known regulation or public involvement in the siting of these pipelines. So it's going to be tough to find where they're going to be. It's going to be tough to get input on whether they should be there. And it's going to be tough, I'm sure, once this stuff gets going and we see the legislators pass laws, it's going to be tough for people to stop it from going through their own backyards, as we see with gas pipelines. So that's it for me. I'm sure we're all hungry.
You mentioned a supercritical state a couple times. What does that mean?
I wish I could tell you. So it's been described to me as it's a pressurized form of the CO2. Because if it's a gas, it's really, really tough to keep it under the ground. If it's just pure, I think it's hard to keep as a pure liquid, and it's very corrosive. But so it's this pressurized state that keeps it in what's called a supercritical state. It's been described to me as not a gas, not a liquid.
And
so Schrodinger's CO2.
It has to maintain that even after it's injected?
Yep. In order theoretically to keep it where it is, there has to be constant pressure to maintain this state.
Okay.
And the next question is, how do you do that forever? Nobody knows.
Well, the same technology used for compressor stations along pipelines, that's the function that they perform, well, even for natural gas pipelines.
But once it's under the ground, there's no compressor.
They can still keep
station
pressure.
underground.
You can still keep pressure on it, but I think almost the better question is what happens when the site what happens when their site closure plan is done and they walk away? Who's watching? There's no answer for that. We're only looking out 50 years, which has been the theme of our climate change problem.
Those of us who are older than 50 have an appreciation for how brief that period is.
Thanks, James.